So in this video, we're continuing on with our series on assault crimes in the state of Florida. And today we're going to be talking about common defenses for these crimes. My name is Adam Rossen. I'm a criminal and DUI defense attorney in South Florida. I'm a former prosecutor. We've helped hundreds of people throughout assault cases, and we have over 350 five-star reviews all over the internet. We like to say that we help good people when bad things happen. So let's jump right in and talk about common defenses to assault crimes. The very first one is the prosecutor's burden, which is proof beyond and to the exclusion of every reasonable doubt. And this is a defense that we use in every single case because by its nature, we have the advantage on any case because the prosecutors need to prove their case beyond and to the exclusion of every reasonable doubt. And what that is that's the highest trial burden in our country. And if you look at this, my hands as the scales of justice, it's almost all the way. It's hard to put an exact number on it, but it's roughly between 90 and 95% guilt that the prosecutors need to convince a jury that my client, is guilty that much. And when we defend these cases, a lot of times we look at the jury instructions. And the jury instructions are basically rules and the law that the jury gets in order to deliberate on a case. And one of the instructions is they're told there's 3 ways to find reasonable doubt. And it's from the evidence, from a conflict in the evidence, and from a lack of evidence. So when we attack and defend these cases, we're constantly trying to chip away at the state's case and expose some kind of reasonable doubt, either from the evidence itself, from a conflict between between witnesses and physical evidence, or just a plain lack of evidence. And that's always used by great defense attorneys in every single case. We really hammer that home. The second common defense is credibility of the victim. And a lot of times the victim or complaining victim or maybe an independent witness, their credibility just isn't there, and we have to attack and expose that. And so I'll give you an example. We had a case once. Client was driving his car and saw a kid that they knew from high school from a few years ago. And they were driving side by side, and the kid owed my client some money. So my client, as they're driving, was calling out to him saying, "Hey, you owe us money, right?" They were kind of yelling, whatever. The alleged victim called the police, called 911, and said that there was a car with 4 black males chasing him, following him, trying to run him off the road. Now, all of that was fabricated. And we knew it was fabricated because the alleged victim knew my client. My client was white. One of the other people in my client's car was black. And 2 of the people in my client's car were mixed. And the victim knew everybody. So if he's gonna lie so blatantly about one detail, right, such as the race of people, right, why would he even lie about that? It makes no sense. I have my theories, but it makes no sense. If he's gonna lie about something as trivial as that, then his credibility is done. His credibility about anything and everything else is done. And that was one big part of the case that we used. And I had the 911 tape. The prosecutors didn't even request it. So we got hired right away, and the very first thing we did was preserve and save that 911 call, which if you don't do, it's gone after 30 days. So in another video, we're going to talk about why you must hire a lawyer immediately after an arrest, and we'll go into more detail, but one of those is to get the 911 tape. Another defense on these cases is if the alleged victim simply doesn't want to prosecute. And in Florida now we have Marcy's Law, which gives victims extra rights and really allows them a seat at the table. So when we have victims who don't want to prosecute, maybe in the heat of the moment they were upset and they've had some time to cool down or cool off and reflect, and they don't want my client or the defendant to be prosecuted or to go to jail or to go to prison, they can sign a waiver of prosecution. And it's not as simple as that, but that's another way where we can help to move cases along and get a great result on a case. Another defense that we use is lack of identity. It's again the prosecutor's burden to prove the identity of the defendant, that the person arrested was actually the person that committed the crime. And a lot of times we call this the Shaggy defense. So if you know the rapper Shaggy, he had that song from about 15, 20 years ago called It Wasn't Me. And a lot of times we use that where we don't have to prove who it was, right? But the prosecutors can't prove that it was our client. It wasn't me. I don't know who it was, but it wasn't me. And that's another common defense that we use. Another one that we use is stand your ground or self-defense. In Florida, for about 15 years or so, we've had the stand your ground laws, which give immunity to anybody who meets force with force. And we'll do a whole nother video series on self-defense and stand your ground, because that's going to take a long time, and it's great content for people to really know and understand. But a lot of these violent crimes or crimes with person-on-person crimes, we have stand your ground or self-defense issues. And we've had plenty of cases that have been dismissed or won at trial due to stand your ground. The last of our defenses to assault crimes would be conditional threat without an apparent ability. So what this is and I'll give you an example on a case that we had. We had a client once got into an argument with some people that he knew, and he said to them, if you don't do X, like if you don't pay me my money, I'm going to go to my car, get my gun, and shoot you. Not the smartest thing, not the best thing to say, but is that a crime, right? That's what we look at as defense attorneys. Is that actually a crime? And the answer would be no, because that's a conditional threat. If you don't do this, I will do this, but it's without the actual or apparent authority to do so, meaning he had to go to his car, get his gun, then make the threat. If, for example, if my client had the gun with him, pulled the gun out, pointed it, and said, if you don't pay me my money, I'm going to shoot you, then that would have been an aggravated assault with a firearm. But because it was one step removed, the law says no, not a crime. And we actually had that case, and we got a fantastic result on that case because we used that defense. So these are some real common defenses that we use on assault and aggravated assault crimes here in Florida. If you ever need help with one of these cases, feel free to give us a call. Go on our website. We have tons of free information. That's why we do these videos, really to separate the truth from the myths out there. And you can call us at 754-206-6200, or you can go on our website again, www.rossenlawfirm.com. We have free strategy sessions where we dive deep into the case, and literally from day one, we'll start working and crafting your defense.